possible to play music behind?
Oh yeah. Do you have it on your phone?
Oh yeah. You see, I was talking about music and I forgot that it has to be played on this phone. Um, let me see. Yeah.
Okay, that's this one. Because that's turned up.
That's what I was actually thought But let's leave it because we have less than a minute now. Let's leave it for now. And remember, we talked about this thing showing all these tables the last time.
Yeah. Oh, do you want it to show this too?
No,
Or
no,
just
no.
that?
I thought it should be closer.
Yeah, that's what I did. Yeah.
Okay, so you set it.
Yeah, I set it so that you can just see, like.
I think I'm even like that. Okay.
Yeah, it's set so it's like right
Um,
here, so it just
remember
kind
we
of
talked
shows
about this thing showing
that.
all these tables. But is it not cutting my head or something?
Is it a little bit?
No,
Okay.
no, no. I thought.
Oh, gotcha. Yeah, that's what I did. Yeah.
Okay, so you set it.
Yeah, I set it.
I hope my voice is not live yet. I think I'm even live.
Okay, that's good. Yeah, it's set so it's like right here, so it just kind of shows.
Okay, okay. Is it not cutting my head? Okay, okay. I can't hear me. I hope my voice. Ah, did you hear that?
Can you hear it?
Hello, hello. Welcome once again. Today is another Wednesday in our series of podcasts. This is Dr. Olu Asekun here. Welcome to another week. This program, by God's grace, we'll be doing it every Wednesday, 12 p.m. Central Standard Time. That is Dallas time. Today, this week, we are discussing petitioning as a religious worker. That is what we are discussing today. So, if you are just joining us, call your friends, your family members. Let everybody share in this information. It is not cool when you monopolize information. We are sharing information to prevent people from making avoidable errors, avoidable mistakes. That is the whole purpose of doing this. So, call your friends, your family, your neighbors to join us so that they can be part of this. And as I will be going over it, send in your questions, because it is when we receive questions that we'll be able to address specific needs. When we receive your questions, that's when we'll be able to address specific needs. In the meantime, talking about religious petition. Religious petitions is one of the employment-based way of getting permanent resident in the United States. There are two categories of religious petition. There is a non-immigrant part and there is an immigrant part. The non-immigrant is the temporary one. That is what we call R1. The immigrant part is the one that leads to green card. Can you please adjust the volume? It's making some noise.
What?
There's some background noise that I'm hearing.
Which one? Oh, I hear yours. Okay, what is that one?
Okay, I think that's the right one. Okay. There are two categories of religious petition. The non-immigrant type, which we call R1, and the immigrant category, which is the I-360. Now, religious petition is one of the employment-based way of getting legal status in the United States. However, it is the only category that is treated differently by immigration. Over the course of this weekly podcast, I've had to discuss what we call labor certification several times. For those who are joining for the first time, labor certification is when when an employer, a U.S. employer, is planning to employ a foreigner, the steps that the Department of Labor expect the employer to take. In other words, every employer that is planning to hire a foreigner, they are supposed to go through a process called labor certification. That simply means that they are supposed to offer the position to American citizens first before they can consider foreigners. And religious petition is the only petition. Anyway, I take that back. The religious petition is one of the three categories of petitions that are exempt from labor certification process. In other words, a religious petition is one of the three that an employer can actually offer the position to a foreigner without considering American citizens first. Those three exemptions are nursing, physical therapy, and religious workers. So what that means is that a religious organization could employ a foreigner without offering the position to American citizens first. Now, because of this exemption, it is prone to abuse. It is very prone to abuse because religious organizations are not required to offer the position to American citizens first, so religious organizations can just go ahead and hire foreigners, whether the foreigners are physically present in the United States or they are outside the United States. Religious employers can petition for them directly without offering the position to American citizens first. So, because this thing is prone to abuse and because immigration have documentary evidence of abuse in the past, the Congress amended the law relating to religious workers in 2009. And when they amended the law, they introduced some safeguards. They introduced some safeguards to ensure that these abuse are either prevented or cured or kind of stopped. One of those steps that was put in place by the new law was the physical inspection. When there is a religious petition, USCIS is required by law to conduct physical inspection of the religious facility to ensure that everything that was stated in the petition is actually true, to verify the information contained in the petition. And because of this, sometimes USCIS, they do the inspection before approval. Most of the time they do it before approval. But for religious organizations that have passed previous inspections, they could do the inspection pre or post approval. They could do it before approval, or they could also do it after approval. Now, because of these changes, because of the steps at the desire of the Congress to prevent abuse of these religious petitions, one of the changes of the 2009 law is that immigration created a dedicated office in California that handles religious petitions. This office is the only office in the entire United States that handles religious petitions, whether the non-immigrant portion or the immigrant portion, whether the R1 or the 360. This dedicated office that is situated in California is the only office that handles the petition. Although the site inspection, the physical inspection requirement can be conducted by other USCIS offices across the country. In other words, if a petitioner, if a religious organization submit a petition, let's say a Texas religious organization submits an R1 petition or a religious worker petition to USCIS, that petition has to be filed and processed in California. But California can authorize a local USCIS office in Texas here to conduct a site inspection, to conduct a physical inspection of the facility to ensure that every information provided in the petition is actually accurate. So the local office will conduct site inspection and then they will report back to USCIS in California, and then the California office will process and take decision on the petition. Now, before I go further, please keep your questions coming so that once I finish the preliminary information, we will go into questions and answers. So please send in your questions while I'm doing this. Keep the questions coming. Now, as I said, there are two categories of religious petitions. The temporary one is the one that is called R1. Prior to the 2009 amendment of the law, R1 used to be, initial R1 used to be approved for 3 years. But subsequent to the amendment in 2009, it is now approved for 2.5 years. But it can be extended for another 2.5 years. But the maximum anyone can stay on R1 is 5 years. 5 years. So if you have been on R1 for 5 years and your I-360 has not been approved, you don't have any pending application for adjustment, you cannot remain on R1 for more than 5 years. They will not even approve it in excess of 5 years in the first place. So in order to keep your eligibility, in order to be able to get green card, you have to find other means to maintain legal status. You have to find other means to maintain legal status. So for R1, the maximum you can be on R1 is 5 years. Now, let's talk about requirements. For temporary religious worker, which is the R1, the requirement is very simple. On the part of there are some requirements on the part of the petitioning organization, and there are some requirements on the part of the beneficiary. Starting with the petitioning organization, the petitioning organization will have to show that it shares the same religious belief. It is part of the same denomination as the beneficiary. In other words, a religious organization here in the United States can only petition for a beneficiary who shares the same religious denomination or same religious belief, mission, and vision with the beneficiary. So, in other words, a Catholic organization, for example, cannot petition for someone who is what other denomination do we have? Maybe someone. Anyway, you have to show that you share the same denomination or you share the same vision or mission. It is a mandatory requirement. In addition, the petitioning organization will have to show that they have the financial capacity. They have the financial capacity to pay the beneficiary the proposed salary. And of course, the petitioning organization will have to show the legitimacy of the job offer. So they have to show that, okay, this position that we are offering to this beneficiary, the position is actually inexistent and the position is legit. It wasn't something that was created just to help the beneficiary. In addition, on the part of the beneficiary will have to show, one, that he or she has been a member of the religious organization for at least 2 years. The beneficiary will have to show that he or she has been a member of the religious organization for at least 2 years. That is a mandatory requirement, 2-year membership requirement. This is one of the differences between the temporary religious petition and the permanent religious petition. For the permanent religious petition, the beneficiary will have to show that he has been on full-time employment of the petitioning organization or at least 2 years full-time employment as a religious worker immediately preceding the filing of the petition. So that is a major difference between the R1 and I-360. Please keep the questions coming. I think questions are coming in. Let me answer the specific questions so that what can I do if my petitioning church is not paying me what they promised when they file for me? Can I get in trouble if they are the ones in the wrong? This is a very good question because this is one of the major questions that we receive all the time. The answer is yes. Both parties can get into trouble. And when I say both parties, I mean both the petitioning organization and the beneficiary. Now, when the petitioning organization filed the petition, they will have stated what the remuneration for the job will be. They will have stated how much salary they have to pay the beneficiary. Yes, not keeping those promises is a violation of law. That may get the employer, that may get the petitioning organization into trouble. It can prevent them from being able to file for other people in the past, in the future. Immigration can also kind of blacklist that kind of religious organization. In addition, they could revoke the petition. This is where the beneficiary may be affected. They could revoke the petition. In addition, because it is the beneficiary's responsibility to show eligibility for any benefit sought, when the beneficiary is attempting to file I-360, they may not be able to, because the I-360 will be denied if immigration sees that the petitioning employer did not comply with the terms of the initial R1 that was approved. So both parties could be affected. So the answer to that question is yes. Now, the other question, what will be the status of the immigrant if she is no longer working with the religious organization that filed for him or her? This is very straightforward. If the beneficiary was approved to work for a specific religious organization, if the beneficiary stopped working for this religious organization before the approval of his or her green card, that means that beneficiary is out of status. And of course, what that means is that if the green card has not already been approved, it may not be approved. That beneficiary will be out of status. However, in some cases, especially if the I-360 has already been approved, in some cases, some beneficiaries do escape it if immigration didn't go back to check whether they are still working for the employer or not. But usually, once the petition is approved and a beneficiary stops working for the employer, the law is that that beneficiary is out of status. That beneficiary is out of status. The next question sent, from WhatsApp. My spouse is on R1 and I'm currently on F1. Will it be better to change to R2 now? Well, it depends. Not that it is better or it is not better. It depends on a number of factors. I mean, it depends on what you are trying to achieve. It does really not affect a whole lot of things. But is it better? Yes, for the following reasons. One, if you are on F1, you'll be treated as international student and you'll probably be paying as international student. On the other hand, when you are on R2, you are not allowed to work, but you are allowed to go to school. And if you go to school, you will not be treated as international student. So you have that advantage. Other than that, there is really no other advantage. When the one that is on R1, if she continues to work for the religious organization and the religious organization file I-360 petition for her and the petition is approved, both of you can apply for green card, whether you are on R1 or on F1. Whether you are on R2 or F1, both of you can apply for your green card. The only thing you cannot do is to be out of status before the application for green card. So that is that. The next question, follow up to the last question. Can I go to school? Yeah, I think I already answered that. Yes, if you are on R2, yes, R2 is not allowed to work, but R2 can go to school. Yes, R2 can go to school, but not allowed to work. But you are allowed to go to school if you are on R2. Yes, and you'll be treated as a resident when you are on R2, not as international student. Yes. Next question, going back to payment, can a church provide housing, a car, or meals in lieu of payment? Is there a minimum amount a church should pay? Yes. The thing is, as I said at the beginning of this podcast, when it comes to religious organization, when they change the law and introduce site inspection, part of the requirement under the new law is that an employer must state in detail what the remuneration will be. Remuneration does not necessarily have to be in salary alone. Part of the remuneration could be housing. Part of the remuneration could be transportation. Part of the remuneration could be other benefit in addition or in lieu of salary. Yes, but the difference is that the point to note here is that those information must have been provided to immigration before the petition is approved. And there are different categories of R1. There is what is called religious occupation, and there is what is called religious ministers. They are different, and the requirements are different. So when you are a religious minister, it is different from when you are in a religious occupation. Example, religious minister must be doing religious duties. Maybe you are a pastor. Maybe you are the minister in charge of evangelism. Maybe other kind of ministers. That is different from religious occupation. Religious occupation, maybe you are the head of choir. Maybe you have some gift in form of, maybe you play guitar, you have some skills that you do for the church. But let me tell you, church administrator is not a position that is qualified for R1. It's not a position that is qualified. Although church administration could be part of the duties that a beneficiary could perform, but church administration itself is not a religious occupation. So you need to understand all this. So from the beginning, the petitioning organization will have notified immigration that, okay, this person that we are hiring, we are going to pay this person $50,000. However, out of that $50,000, we are not going to pay cash. We are going to pay housing for this person. That housing is worth $12,000. Maybe it's $1,000 per month. In addition to that, we are going to provide transportation for this person. Maybe that transportation, we value it at about $300 per month. So all that specific information must have been stated in the petition, and immigration will have taken all that into consideration before approving it, so that when you apply for I-360, it will not be a problem, because your pay slip or your W-2 or your tax return does not necessarily have to show 50,000 at this point. But it is different if the petition was filed and in the petition, the petitioning organization stated in their petition that they are going to pay a salary of 50,000. Now, if that petition was approved based on that information, and then the employer now decided to start providing housing, and that would not be in compliance with the petition. The right thing to do in such a situation is to file an amended petition and indicate how the employer intends to pay the beneficiary specifically. You cannot assume that, because you now get housing, you now get this, you are complying with the law. If that was not stated in the initial petition, there will be trouble ahead. Then the last part of that question, is there a minimum amount a church should pay? Well, there is no minimum amount that the church should pay. However, like I said, the religious organizations are given a lot of leeways. They don't treat them the way they treat secular employment. However, no matter how much the employer intends to pay the petitioner, it must not be less than minimum wage. So immigration is federal. Immigration is covered by federal law. It's not covered by state law. So the employer must look at what is the federal minimum wage. So whatever the religious organization is offering the beneficiary must not be less than federal minimum wage. The next question. I have a church in Mexico. I have been wanting to start a new chapter of my church in US. If I start my own church in the US, can I use it to petition for myself? No. The answer is no. The religious organization, the religious regulations does not permit self-petition. You cannot establish a church and use the church to petition for yourself. If that is allowed, there will be nobody illegal in the US. Everybody will just come in, start a church, then use the church to petition for themselves. So definitely that is not allowed. However, a branch of your church could still be started in the US. You could get maybe followers or other members of your church who are probably already in the US in legal status, of course, preferably US citizen, who could start the church on your behalf and then use the church to invite you in or petition for you to come and pastor the church. But you cannot come in, register a church, start a church, and then use that church to petition for yourself. That is not allowed. Okay, keep the questions coming in. Keep the questions coming in. I believe that I've answered all the questions that came in so far. Keep the questions coming in. Keep the questions coming in. Let's take a short break. But in the meantime, keep the questions coming in. Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work because like I told you, I'm like a member of this family, and call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I announced, okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. So, okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on. And I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved. And I got my approval. The entire office, they were so happy, they were jubilating as if It was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in her face, and we were able to get her substantial amount of money from the insurance company. Even after paying all her medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me.
Please keep the questions coming. Keep the questions coming. We are back. I think I received a question on my direct line. Hold on a minute. Okay, yes. The question is, what of when a couple with R1 and R2 are filed 485, but they separate? Can each party continue the adjustment of status on their own? This is a very technical question. Very, very technical question. The answer depends on a number of factors. Number one, for as long as the beneficiary, the one that was on R1, the one that got the R1 approved, for as long as that person is still working for the religious petitioner, yes, they can keep the green card. However, if they are separated, because the one that was on R2 does not have any obligation to work for the employer or to be in a particular place, they could be separated. He or she could relocate to a different state. She will still get the green card. On the other hand, if it goes beyond separation, if it became a divorce, and on the day of the divorce, the green card has not been approved, then it may become an issue for the one that was on R2. Especially even if the green card is approved later, the one that was on R2 may get into problem later, even when applying for citizenship, because at the time of citizenship, she will have to disclose the time that her marriage ended. She will probably have to be required to submit a divorce decree. And if they realize that the marriage ended before the green card was approved, they could accuse her of obtaining the green card fraudulently, because she has an obligation to notify immigration when the marriage ended, if at that time the green card has not been approved. But if it was just legal separation, no final decree, yes, she could keep her green card without any implication. So please keep the questions coming. Let me try to see if there are other questions. Please keep the questions coming. There are new questions? Oh, the church has been... Oh, okay. I missed that. Thank you for calling my attention to that. Okay. There's a question that I missed, so let me go back to it. The church that petitioned for me is giving me problems and not living up to promises. Can another church petition for me instead? How will I go about that? Okay. This is one of those things that we see from time to time. And I keep saying the reason we do this podcast is not because we have any hidden agenda or anything. It is just to provide information to prevent people from making avoidable mistakes. This is one of the major areas where we have challenges. When religious organizations petition for beneficiaries, stating in their petition that they will do ABC, and then upon approval, they are not able to keep those promises. It's a major problem, especially within the African community. It's a major, major problem. Now, to go back to this question, can another church petition for you? Yes, another church, but the church must be either the same denomination or must be a church that shares a religious belief and vision or mission. Remember, when the initial church petition for you, you will have had to prove that you have been a member of that religious organization for 2 years. That is the minimum requirement. So if you have told immigration, let me use some hypothetical churches now. Let's say you have told immigration when the initial filing was done that you are a member of the Catholic Church and the petition was approved. Now, the Catholic Church that petitioned for you did not fulfill the condition and you want to move to maybe a redeemed church. That would be problematic because you cannot turn around after showing evidence that you have been a member of Catholic Church. You cannot turn around and prove that you have been a member of Redeemed Church for 2 years. That's going to raise a major red flag, and it can lead to fraud. It can lead to finding of fraud in this type of petition. So it's a very delicate issue. But if you find a new religious organization that is either the same denomination or share the same religious belief or the same religious vision or mission, they may be able to take it. They may be able to take the new petition. Again, you will still face some other challenges. When we file a transfer or a change in employment, when we file that kind of petition, immigration may require you to show evidence that you actually complied with the terms of the initial one before they approve you for a new one, or before they approve a change for you, or before they approve a transfer to a new petitioner. Most of the time, 95% of the time, immigration will want to see evidence that you have actually been complying with the terms. Usually, they may ask for your pay slip. If your remuneration is the type that indicate that housing, transportation, and other form of remuneration apart from salary is part of it, they will want to see proof that those things were actually done before they go ahead to approve you for a new employer. That is where you are going to run into trouble, because if the employer did not fulfill that promise, you may not have a pay slip or W-2 or tax return that will show compliance with the approved petition. You may have that challenge. Now, when I'm talking about compliance, it is two ways. If the religious organization that filed the petition, if they offer you something more than what they told immigration they were going to do, that's not a problem. It is only a problem when they offer you less. In other words, if a religious organization petitioned for you and stated in the petition that they are going to pay you $50,000, if they end up paying you $70,000, immigration will not question it. That's not an issue. But if they end up paying you $20,000 or they end up paying you $30,000, that is when immigration will raise an issue out of it. So you need to understand all that. Keep the questions coming. I have a new question from WhatsApp. At what point can you apply for green card on an R1? Upon the approval of the green card, are you still bound to be in the church that filed for you? Well, as I stated at the beginning of this podcast, the requirement for R1 is different from the requirement for 360. For R1, you have to show that you have been a member of the religious organization for at least 2 years before the petition was filed. For green card, for 360, which is what you use for green card, you have to show that you have been in full-time employment with the religious organization for at least 2 years. For the R1, you don't have to show employment. You need to show membership. For the 360, you have to show employment, 2 years full-time employment from the date the petition was filed. So they count that 2 years backward, and there cannot be a gap in between. For example, if you have been on R1 maybe since 2020 with a religious organization, maybe by December 2022, you stop working for the organization, maybe they stop paying you, and then March 2023, they come back and decide to file I-360 for you. Immigration is going to deny it because that does not meet the requirement. The requirement is 2 years full-time employment immediately preceding the filing of the application. So when you file the application, the day immigration received that application, that is the day they will count 2 years backward to find out whether you are eligible for I-360 or not. And of course, upon the approval of the I-360, that is when you can now apply for green card. Now, to answer the question about after the green card, yes, after the green card, if you stop working for the petitioning organization, it's not going to be a problem. However, there is something you need to pay attention to that I need to point out. Whenever you apply for citizenship, you are going to have to tell immigration your employment history in the last 5 years. Anybody applying for citizenship, irrespective of the category, you have to state your employment in the last 5 years. So, if you get your green card today and stop working for the employer, yes, it doesn't affect your green card. You get to keep your green card. But when you apply for citizenship, in the application form for citizenship, you are going to have to answer your employment history in the last 5 years. So if at that stage, if religious employment does not show in your employment history, immigration can raise the issue. It can be a problem. Now, it doesn't have to be religious employment with the petitioning employer. It could be a different employer. It could even be self-employment. It could even be your own ministry. It could be something, but you just have to take that into consideration. You cannot tell immigration before you get your green card that you are a full-time minister, you are a full-time religious worker, and then as soon as you get your green card, religious employment disappears from your resume. Then when you face your citizenship, you have to answer the employment history for the last 5 years. That may be an issue. So it is not a wise decision to throw away the religious employment just because you now have your green card. If you don't want to work for the employer, go into your own private ministry. Do something religious, but don't throw that card away. And if you choose to, if you find yourself in a situation where you have to, then I tell you, don't rush into applying for citizenship. Because if you do, you have to answer that question of 5 years employment history, and it may be problematic for you. But if you delay, your green card is going to be valid for 10 years. It could also be renewed for another 10 years. So you could keep your green card for some time to give room for that 5 year immediately after your green card to evaporate from your record. So I believe I've answered that. Please keep the questions coming. Keep the questions coming. Is there any question? Okay. At what point can you apply for green card on R1 upon your approval? I think I've already answered that. Okay. New one, new question. I was contacted by a church that has petitioned for other people. It's a big church that has filed for 5 people. Is there a maximum number of people a church can file for? Good question. The simple answer is no. There is no maximum that a church can file for. There is no maximum that a church can file for. What matters is the capacity of the church or the religious organization to pay salary. Remember, I said at the beginning of this podcast that immigration is going to conduct site inspection. They are going to conduct physical inspection of the religious facility. So they are going to find out if there is really need for these positions. Because sometimes, in this type of example, because because this church has petitioned for 5 people, sometimes immigration can ask the church, the petitioning employer, to state all the positions that are occupied in the church. So they want to see if the position that they are just petitioning now is if somebody else is already doing that work. They want to see. But if the positions are different, if they are not the same, and the church can demonstrate that they have the financial capacity to pay all of them, there is no limit. I mean, I've represented churches in this metroplex, in this DFW metroplex, that have petitioned for up to 12 people. There's no limit for as long as the positions are different and they have the financial capacity to pay. And because immigration also conducts site inspection, they do go there to verify that all these things that are stated in the petition, they are actually true. Once they verify that they are true, once they verify that the church has the financial capacity to pay the beneficiary, and they realize that the positions are legit, they are not the same as the work that somebody else is already doing, they will go ahead and approve it. So there is no limit. There's no limit. Please keep the questions coming. Keep the questions coming. Please keep the questions coming. Okay, I think we have a new question. Can I apply for an R1 while in my home country? Can I travel to the US and wait for the R1 approval if I already have a B1, B2 visa approved? Well, this is a two-sided question. Can you apply for R1 while in your home country? The answer is yes. Remember, this is an employment petition. You are not the applicant. The U.S. religious organization is the applicant. So, a U.S. religious organization can petition for someone who is either physically present in the U.S. or who is outside the U.S. in his or her home country. So, the answer to that question is yes. A U.S. religious organization can petition for somebody who is still in or her home country. Now, the second question, can I travel to the U.S. and wait for the R1 approval if I already have B2 visa? Yes and no. Yes and no in that at the time the petition is filed, if you are still in your home country, the petition there is a portion of the petition that asks the question, is the beneficiary in the U.S. or is the beneficiary out of the U.S.? So at that stage, your petition will have indicated that you are outside the U.S. Then the next question in the petition, there's a question that says, if the beneficiary is outside the U.S., please select the country or the consulate where you want this approved petition to be sent. So all this information will have been included in the petition. The petitioning organization will have indicated your home country. They will have indicated the U.S. consulate that covers your home country, and they will have requested that the petition be forwarded to that place. Now, while the petition is pending, can you use your B1, B2 to enter the U.S.? Yes, of course. You can use your B1, B2 to come to the U.S. But when the petition is approved, you will have to go back to your home country in order to get the R1 visa, because that information would have been provided in the petition at the time the petition was filed. Because when the approver in that situation, when the petitioning organization gets the approval in that situation, that approval is not going to have any I-94. That approval is going to have the name and the address of the U.S. consulate where the beneficiary is supposed to appear. So if you stay in the U.S. after that approval, you are going to be illegal because you will not have any I-94 that makes you legal here in the U.S. Please keep the questions coming. Keep the questions coming. Keep the questions coming. I'm happy to continue answering the questions, but if there are no questions, there will be nothing to talk about. So please keep the questions coming. Keep the questions coming. Please keep the questions coming. Okay, no questions. Okay. Okay, we have a new question from email. Can I come in as a guest minister while on B2 visiting visa? In fact, this is one of the most, by the time I answer this question, I will tell you this is one of the most educative questions that anyone can ask, because this is one of the areas where pastors and ministers get into trouble, especially pastors who come into the U.S. to minister. This is one of the areas where they get into trouble. To answer the question, can you come in as a guest minister while on B2 visiting visa? The answer is yes. But can you minister and be paid? The answer is no. I am familiar with the way religious organizations work. As a Christian myself, I know that ministers do get honorarium, but that is illegal. That is the problem. That is illegal. Can you minister? Yes. Can you be paid for ministering? No. It doesn't matter what coloration they put on the payment, whether they label it honorarium, whether they label it gift, whether they label it salary, whatever it is labeled, it is illegal. I've seen so many ministers who have done this over the years successfully, but maybe just on one of the entries, somebody, maybe a CBP officer, will just ask some funny questions, and because these people don't know the implication of what they just did, then they will own up. I have a case of a client some years back. He came into the US from Africa. He plays guitar and instrument, is well gifted. Now, he came during the RCCG North American Convention. And maybe because of his contact with some other people who are instrumentalists and all of that, he was invited and he played the instrument during the convention. After the convention, he went back to Africa. On a subsequent visit, they asked him question. Oh, the last time you were here for about 3 months. He said, yes. How are you able to take care of yourself for 3 months? He said, well, the last time I was here, I ministered at a convention. I was giving some honorarium. I was this, I was that. Because he didn't realize those things are illegal. Guess what? Not only was he prevented from entering, but his visa was revoked. So, going back to your question, can you come in with your B2 visa to minister? Yes. Can you receive any form of remuneration for doing it? No. Another question. Please keep the questions coming. It is when you ask questions that you encourage us to keep doing this. When you don't ask questions, there will really be nothing to do. So keep the questions coming. Follow up from WhatsApp. Okay. For someone that changed status from B1 to R1, upon approval of your I-360 green card, you travel to your home country without parole, or will there be no need upon approval? Oh, apparently this person doesn't know the way immigration works. So once you already have green card, you don't need parole. Except, well, there are different types of parole. Let me clarify it. Yes, there are different types of parole. There are some parole that is called advanced parole. Those are temporary parole. Those are kind of permission that allows you to come back to re-enter the US after a temporary trip abroad. Those are temporary parole. We call it advanced parole. However, there is another form of parole that green card holders apply for. We call it travel document. We don't call it parole. We call it travel document. Now, the difference between the two is that when you already have a green card, when you apply for that travel document, you are given immigration notice that I will be going out of the US for an extended period. Extended period up to 2 years. Now, immigration will approve it and give you a kind of passport. It is different from US passport, but it is issued by the Department of Homeland Security. So you take that passport and your green card with you, and then you travel out of the US. You can stay out of the US for 1 year, for 1.5, for 2 years. When you come back, no questions asked. You are not going to be presumed to have abandoned your permanent residency. Because if you don't do that, if you travel with your regular green card and you stay out of the US for up to 1 year or more, there is a presumption in law that you abandon your permanent residence. And upon your entry, they may question you to actually determine whether or not you have abandoned your permanent residency. And if you are not able to rebut that presumption, you may be denied admission. So those are the type of, but the initial advanced parole, the one you apply for before you get your green card, you don't need that after you become a permanent resident. Once you have your green card, you can travel out of the country for a short period. There is no problem about that. So please keep the questions coming. Yeah, I think I've answered this last question. Please keep the questions coming. It is encouraging when you ask questions. When you don't ask questions, there is really nothing to do. As I've said over and over and over, this program is every Wednesday, 12 p.m. Dallas time, that is Central Standard Time. The whole purpose is to provide information. The whole purpose is to prevent our people from making avoidable mistakes. There is no strings attached. There is no consultation fee required. Just log in and join us. Tell your friends. Subscribe to our channel so that when we go live, you are notified. Nothing more than that. Keep the questions coming. Okay, I think we just got a question. Another question from WhatsApp. Doctor mentioned site visit for the churches. Will the beneficiary worker need to be present and answer questions from USCIS? Well, it is not a mandatory requirement, but most of the time, the site inspector will usually want to talk to the beneficiary as well as the petitioner. The inspection is all about the petitioner. The beneficiary is not required to be there, but sometimes the inspector may request to talk to the beneficiary. Remember, when you file this petition, you are not allowed to work for the employer until after approval. So, even if you are there in the church when the inspection comes, that may be a problem for you. If the inspector finds out that you have started working for the employer before approval, that will be a violation of the law. So, the beneficiary is not required to be present. But if for any reason the beneficiary is there, then you want to ensure that the beneficiary was not there because he or she already started working for the employer. Because if the inspector finds out that the beneficiary already started working for the employer before approval, that could actually lead to denial. When an R1 petition is filed, the beneficiary is not permitted to start employment until after approval. The beneficiary is only allowed to commence employment after approval. Now, this is different from an extension. I don't want you to mix these things up because they are different. If everything I've explained so far is about initial petition, if your petition was previously approved and you already started working for the employer, and now the employer filed a second petition to extend the R1, that is different. In such a situation, the law allows the petitioner to continue to employ the beneficiary for up to 10 months. The law allows the beneficiary to continue working for the employer for up to 10 months from the date of the second petition. Up to 10 months. That is to give them time to process it. If the extension application was not approved within 10 months, then the beneficiary must stop working for the employer and wait for the approval of the extension. But when an initial petition was filed, the beneficiary cannot work for the employer until after approval. When an extension application is filed, the beneficiary can continue working for the employer for up to 10 months to allow USCIS to adjudicate the petition. If the petition has not been adjudicated within 10 months, then the beneficiary must stop working for the employer until after the petition is approved. Okay, keep the question coming. Okay, another question. How long does it take to get a green card based on an approved I-360? Can I work for the church while the green card application is pending? I'm sure whoever asked this is probably one of the latecomers. Maybe the person just joined because I've actually answered the second part of this question, which is, can I work for the church? Yes, you have to. Not that can you work. It is mandatory that you continue working for the church while the green card application is pending. It is mandatory that you continue working for the church. How long does it take to get a green card based on an approved I-360? Now, this is a very difficult question for me to answer correctly, because immigration has been time, when it comes to processing time, it has been messed up since COVID. It is becoming extremely difficult for anybody to predict the timeline for any application. The reason is simple. When you have a green card pending, it falls within the category of all I-485. I-485 is application to register permanent resident or adjust status. That is the application for green card. Everyone applying for green card based on employment, even based on family, anyone who is physically present in the US and is applying for green card has to submit Form I-485. So now, if you are checking the processing time for Form I-485, the last time I checked, and I believe that was this week, it was showing about 32 months. The processing time is showing about 32 months. Now, the reason why I said that it is difficult to predict is that we actually have, in my office, we actually have I-485 that was filed around middle of last year? About middle of last year, based on approved I-360, and the green card is already approved. So sometimes you cannot use that as a yardstick to predict that others will be fast like that, because this one has not even been pending for 1 year. And if you are looking at the processing time of 32 months, 32 months is almost 3 years, because 12 months is 1 year, 24 months is 2 years, 36 months is 3 years, and the processing time says 32 months. So that's almost 3 years. Yet we have application I-485 based on an approved I-360 that was filed and approved in less than 12 months. So these things are not predictable. I always tell people, immigration is not a one-cap-fits-all. The fact that this one was approved this fast does not mean the next one is going to be approved that fast. In my office here, we have filed I-360 that was approved within 3 weeks. Yet, we have also filed I-360 that was not approved in 1 year. So, there are so many factors that affect this thing. And of course, it also includes individual USCIS officers. So, many of these things are not predictable. So, that is a question that is so difficult to answer. It is extremely difficult to answer. Imagine the 360 that we filed and was approved in less than 3 months and within 3 weeks. Imagine if the one whose 360 has been pending for 1 year, if he or she was using a different lawyer, imagine what the one that got his own approved in 3 weeks will be telling him, oh, go to my own lawyer, my lawyer is better. Oh, if my lawyer file it for you, you get it approved in 3 weeks. No, it doesn't work like that. It does not work like that. But I can guarantee you one thing that helps adjudication is if your file is complete, it will be fast. That I can assure you. I can guarantee you that. If immigration picks up your file and there is no need to issue an RFE, your case will be approved very fast. So, I hope I've been able to answer that. The next question, okay, follow up. If the green card application is past the posted processing time, what can I do? It is almost going to be impossible. I'm not going to say it's impossible, but it's almost going Apologies. I think something happened. I don't know if people can even hear me now or not. Yeah, if you can hear us, sorry, we apologize about that. Uh, that's one of the problems with technology. The whole thing just went offline. Yeah, if you can hear us, please keep the questions coming. Keep the questions coming. Are you live? I'm not able to go live, so I don't even know if they posted any new questions. Okay. Okay, yeah, I think I'm live now. Yes, I think I'm live now. Yeah. Please keep the questions coming. We apologize about that. That's one of the problems of technology. The whole thing just freezed. So we lost connection for a short period. Please keep the questions coming in. We are back live. Please keep the questions coming. Okay, yes. There's a new question. Is there a reason why you can't file the green card application concurrently with the I-360 like you can with family-based applications? Well, this is a very good question. Yes, there are several reasons, and I will explain the reasons. Even this, your question is not even accurate because it is not every family application that you can file green card concurrently. When you are talking about family application is categorized into 6 categories. We have the immediate family. Immediate family category, that is the only category that you can file concurrently. In addition to that, we have what we call first preference category. That is U.S. citizen petitioning for unmarried child who is over 21. We have the F2 category. That is permanent resident petitioning for family members as well as unmarried child over 21. We have F3 category. That is U.S. citizen petitioning for married children. And then finally, we have the F4 category. That is U.S. citizen petitioning for siblings. Out of all these categories, the only one that you can file concurrently is immediate family. That is when a U.S. citizen is petitioning for spouses, minor children under 21, or parents. That is the only one you can file concurrently. Now, going back to the employment-based, religious petition is employment-based. Every employment-based petition, they have numerical limit. And again, every family-based, with the exception of immediate family, they have numerical limit. So there is a limit to how many green cards that immigration can approve annually. So because they have this limit, they don't allow people to file concurrently, because if they do, that will create processing or administrative bottleneck for immigration to start looking at which one do we approve, which one do we not approve. So they don't allow that because there is a numerical limit to the number. In fact, for the entire employment-based category, which includes EB1, EB2, EB3, EB4, and EB5, in the entire 5 categories, immigration can only approve 140,000 green cards annually. Out of that 140,000 green cards annually, EB4, which is where religious application, the I-360 based on religious organization, EB4, that is the category where they fall into. They are only given 7.1% of the 140,000. I'm not very good in mathematics, but can you please help me find out what 7.1% of 140,000 is. They are only given 7.1% of the 140,000. So it is not something that is available throughout the year. So that is why, okay, so the 7.1% is 9,800. So immigration can only approve 9,800 green card application in the EB4 category. And let me tell you, when we are saying EB4 category, it is not only religious petitions that are in the EB4 category. It is the same EB4 categories that asylum applicants, those who are granted asylum, if they want to apply for green card, they also apply in the EB4 category. So those employees who have worked for the U.S. Embassy for at least 10 years meritoriously and they retired, not that they were fired, if they want to apply for green card, they also apply in this EB4 category. So this 9,800 figures is for the entire EB4 categories. So that is why they are not allowed to file it concurrently, because if they do, it will create administrative bottleneck. They will not know which one to approve and which one not to approve. But when the I-360 is filed separately and approved, even the fact that the I-360 is approved does not mean green card will be approved. You still have to wait and ensure that visa is available for the EB4 category before you can submit I-485 application. So it is because of the limited number of green cards and the limited availability in the EB4 category, that is why they do not allow them to file it concurrently. And like I said, the same thing is applicable to family-based. The only exception in the family-based category is immediate family. Every other category, every other one from the one that I've listed, they cannot also file concurrently because they have limited number of visa availability, limited number of green cards that immigration could approve annually. Please keep the questions coming. I think I have another question. Okay. Please help us flash the WhatsApp number to reach or join this live program. Thank you. Okay. If you want to call us live, the WhatsApp number is 817-983-4499. 817-983-4499. You can reach us on our number. You can call directly or you can call through the WhatsApp. But the number is 817-983-4499. 817-983-4499. So keep the questions coming. We have about 30 more minutes to go today. So keep the questions coming. It's been encouraging so far. When you ask questions, we are able to answer. And that is the whole purpose of this program. So please keep the questions coming in. 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 This program, by God's grace, will be every Wednesday, 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. So, let your family and friends know about it. Join us, subscribe to our channel so that when we go live, you'll be notified. Keep the questions coming in. Today we are discussing religious petition, but that does not mean that if you have other questions you cannot ask. Keep the questions coming in. So you can chat your questions live. You can also send your questions to our WhatsApp. The WhatsApp number is 817-983-4499. 817-983-4499. Keep the questions coming in. Keep the questions coming in. Yes, we have new questions. But keep the questions coming in so that once we answer this, we go into the next one. Okay. Can someone that is applying for a religious-based green card work I believe this person wanted to say part-time, for some part-time somewhere when they get the work authorization? I'm not sure. Can someone that is applying for a religious-based green card work part-time somewhere when they get the work authorization while also working for the church? I'm going to tell you no. And the reason I'm going to tell you no is this. Until the green card is approved, immigration can check you out at any time. And because the statute that creates the employment-based category of religious organization, that statute used the word solely, S-O-L-E-L-Y, solely. Because that word is used in statute, immigration has interpreted that word to mean exclusivity, to mean that you can only work exclusively for the church, for the religious organization, and nobody else. I have seen people whose I-360 has been approved, whose employment authorization has been approved, and then they started doing business on the side. And immigration got to find out they not only revoked the employment authorization, they revoked the I-360, and they even went back to revoke the R1. So that person is out of status today, despite the fact that the R1 has been approved initially, the I-360 has been approved, employment authorization was approved when 485 was filed. This person today is out of status because he was doing business. The law that created this religious-based petition, that law used the word solely, solely, S-O-L-E-L-Y, solely, meaning that is the only work you are authorized to do. That is the only job you are authorized to do, at least until you get your green card. You can do 2-3 works after you got your green card. You can do all of that. But while your application is pending, if you do a part-time work and immigration finds out, it will be a ground to deny your green card application. So I hope I've been able to answer that. Please keep the questions coming. Okay, there's a new one. You mentioned that people on R2 can go to school. Yes, that is true. What about people on R1? Can someone on R1 take college classes? Again, I think I just answered this question from my answer to the previous question. R1 simply means that you are authorized to work exclusively for the petitioning organization. You cannot take college classes. You cannot take college credit except if you are taking it in a religious profession. Let's say you decide to go to Bible college. Yes, you can go to Bible college part-time while on R1 because that is still in connection with religious work. But you cannot go to you cannot go to school for a secular program. You cannot do that. If you do that and immigration finds out, then whatever has been approved for you will be revoked. And if your application was still pending, they are going to deny it. Let me tell you this. Immigration will find out. It is almost certain that they will find out. The reason they will find out is through public record. The United States is an electronic country. Everything we do here on day-to-day basis, they all form part of public record. If you receive mail, it is public record. If you work, it is public record. If you apply for driver license, it is public record. If you have a job, it is public record. If you rent a house, it is public record. Everything
everything, if you buy a car, it is public record. Insurance is everything we do on day-to-day basis, they all form part of public record. So it's just a matter of pulling your public record. They will know. They will know. The only time you can escape it is if the officer that is assigned your case, maybe the officer for some reason didn't bother to check you out. Yes, sometimes people escape it. But I tell you, even if you escape it, you are still not off the hook until after your citizenship. Because if you escape it at the green card level, they can still bring it, they can still revisit it, even when you apply for citizenship. So that is why it is very, very important that you comply with the law and not do anything that can jeopardize the approval of your green card or even your citizenship in the future. So you can take classes if the classes is religious. If you go to Bible college or even if you go to a standard college, for as long as the courses or the classes you are taking is religious in nature, yes, you can do that part-time. But if it is not, it will be a violation of your status. Please keep the questions coming. Okay, the next question. Does someone on an R1 visa need to keep a current passport? What do you do if your passport is about to expire? Well, if your passport is about to expire, apply to renew it. But to be honest with you, it's not a requirement if you are not planning to travel. Because the truth of the matter is, if you are on R1, your passport is only relevant when you are traveling out of the US. So if your employer decides to file I-360 for you, the validity of your passport is not relevant to the I-360. If the I-360 is subsequently approved, the validity of your passport is not relevant to the approval of your green card. The only time it will be relevant is your ability to travel outside the country. That is the only time it is relevant. However, if you are on R1 and you will not accrue 2 years before the expiration of your R1 and you intend to apply for an extension of your R1, then you will need to have a valid passport. I hope you get that distinction. If you are on R1 and you will not be able to accrue 2-year full-time employment to be able to be eligible for I-360 before the expiration of your R1, then you will need a valid passport, because without a valid passport, you cannot file an extension of your R1. Because remember, I said at the beginning, R1 is a non-immigrant status. Every non-immigrant status requires the beneficiary or the applicant to show that he or she intends to return to his or her home country at the end of the authorized period. So, if you are planning to apply for an extension of your R1, you have to show a valid passport, because without a valid passport, that will create the impression that you do not intend to go back to your home country. Now, you can show evidence that you have applied for an extension. You do extension of your passport. You don't necessarily have to show that it has been approved. So, if you apply to renew your passport, you pay the fee, you have the receipt and all that, that will be sufficient for this purpose. So I hope that is very clear. Okay, next question. Another WhatsApp question. Can your child that is on R2 be treated as an international student when going to college? No. I've answered this previously. If your spouse or your children are on R2,
they are authorized to go to school and they will be treated as residents. They will not be treated as international students. Remember, every international student, they are required to obtain I-20. They are required to be on F1. So your child is already on R2. Your child is not classified as international student. No I-20 is required, and your child can go to school as a resident with R2. They are not required. They are not going to be treated as international students at all. Well, it doesn't matter whether it is high school or college. They will be treated as a resident. Of course, they will still have their limitations. They will still be treated differently from U.S. citizen or from permanent resident, because there will be a lot of things that they will not be eligible for. They will not be eligible for maybe student loan. They may not be eligible for grant, but they may still be eligible for some form of a scholarship. But more importantly, they will be treated as a resident for as long as they have stayed. At least I know for the state of Texas, you must have been in Texas for at least 1 year for you to be treated as a resident. So the fact that you are on R2, you are not going to be treated as international student. You'll be treated as a resident. Okay. Another question. If someone is trying to get an R1 visa from a church that has similar belief to their own, what should the person provide to show the beliefs are similar? Well, again, this is when you are talking about religious petition, this is not the responsibility of the beneficiary. This is the responsibility of the petitioner. But in order to show that the religious beliefs are similar, if they have constitution, yes, you have to show the constitution of the two different organizations. If they have maybe bylaws, in the U.S., most non-profit organizations are required. It's a mandatory requirement. Most non-profit organizations are required by law to have bylaws. So you can show the bylaws, you can show the constitution of the two churches, you can show the statement of faith, you can show any form of documentary evidence that is available. That is what you can show as evidence that they share the same religious belief. You can also show evidence of affiliation. There are some churches outside the U.S. that are affiliated with religious organizations here in the U.S. So the affiliation agreement is another thing that you can show. So there are a lot of things that can be shown as evidence of sharing similar beliefs in order to get R1 approved. Please keep the questions coming in. As we said, this is a program that is going to be, we are going to continue it every Wednesday by God's grace. Every Wednesday, 12 p.m. Central Standard Time. That is Dallas time. So join us every Wednesday, 12 p.m. Central Standard Time. So invite your friends, invite families. It's free of charge. There is no strings attached. All you need to do is just to log in and ask all your questions. We do this every Wednesday by God's grace, 12 p.m. Central Standard Time. That is Dallas time. You can send in your questions ahead of time if you like. You can wait until we go live and ask your questions. You can also send in your question through our WhatsApp number, which is 817-983-4499. Our WhatsApp number, once again, 817-983-4499. 817-983-4499. You can also subscribe to our channel so that when we go live, you'll be notified. Hopefully, we will continue this for as long as we receive questions. So when you ask questions, that's when we are able to continue with the program. Okay, I think we have a new question. I'm the petitioner for a religious-based petition. Can I expedite my petition? Yes, but I will explain. The religious organization is the petitioner. That is, the church or the religious organization is the petitioner. However, in order to be eligible for expedited processing is what we call premium processing. It attracts additional filing fee, which will enable USCIS to process the petition within 15 calendar days. Now, I want you to pay attention to my answer because it's a little complicated and I want you to get the distinction. You can expedite R1 if the conditions are met. No religious organizations can expedite 360. You cannot expedite I-360, but you can expedite R1 if the conditions are met. Now, what are the conditions? In order for you to expedite, to be eligible for expedited processing of a religious petition, the petitioning religious organization must have passed site inspection. So what that means is that it must be a religious organization that has petitioned for someone in the past. So you must have passed site inspection. Immigration officers must have visited that religious organization. They must have asked questions and they must have been satisfied. So the previous petition that was filed must have been approved because approval is an evidence that USCIS was satisfied with the petitioning organization. So if the petitioning organization has passed a site inspection within the last 3 years, yes, they will be eligible for expedited processing. So expedited processing is not available for everyone, especially first-timer. Any first-time petitioner is not eligible for expedited processing. Only religious organizations that has previously passed a site inspection can expedite the petition. Please keep the questions coming. We have about 15 more minutes to go. Keep the questions coming. We have about 15 more minutes to go. Join us every Wednesday by God's grace, Dallas time, 12 p.m. That is Central Standard Time, every Wednesday. So today we are discussing religious petitions. So keep the questions coming in. That it does not mean that you cannot ask any other question outside religious petition, but religious petition is the topic of the day. So keep the questions coming in if you have more questions. We have about 15 minutes to go. Keep the questions coming in. Okay, I think another question just came in. Do my family members automatically get R2 visas when my own R1 is granted? Well, this is not a yes or no answer. This kind of question will require some explanations. It's not a yes or no answer because we see this type of scenario all the time, and we see family members who are denied R2 visas, and I will explain why that could happen. Now, especially people from African countries, there are some basic differences culturally between African culture and American culture, especially when it comes to religious petitions. In America, when somebody claims to be a religious worker, an average American expects such a person to attend Bible college. They don't expect somebody who claims to be a religious worker to go to college and study architecture. They don't expect somebody who claims to be a religious worker to go to college and study accounting. They don't expect somebody who claims to be a religious worker to go to college and study law or study medicine or study architecture. To them, it does not make sense. But this happens in Africa. You see, in fact, if you look at majority of the African church leaders today, you will see that they are all professionals. They all have different professions outside of the church. For example, the leader of the general overseer of the RCCG, Redeemed Christian Church of God, Pastor Adepoye, is a mathematician. I don't know the church of this Pastor Bakri. I don't know the church, but I know that Pastor Bakri is a lawyer. These are things that are strange to Americans. So, going back to this question, when you apply for visa before you leave your home country, you will have told them what your profession is. You will have stated, maybe you are a banker, maybe you are an engineer, maybe you are a lawyer, maybe you are an accountant, maybe you are an architect. You will have indicated all this in your application at the time that you are applying for visa. Now, they granted you visa based on all this information. You came to the US and suddenly you became a religious worker. You now have a religious organization that is putting you forward as a religious worker. Again, because Americans don't question people's religious tendencies, immigration can go ahead and approve it. You have R1. Now you want to bring in your family from Africa. Your family apply for R2 visa. The embassy is looking at your visa application. They are looking at your credentials. They are looking at your record. They are saying that you are a banker. They are saying that you are an accountant. They are saying that you are an engineer. Do you think they are going to approve the R2 visa? Probably not. Probably not. They may not. One, R2 visa by itself is a discretionary form of application. It's a discretionary visa. So the fact that your record does not also support the fact that you are a religious worker, that is another problem for them. That is another red flag. In fact, let me tell you this. In my practice, I have seen situations where, for reasons best known to immigration, I don't have access to their database, so I cannot really predict what the source of the red flag is. But I've seen situations where USCIS decide to investigate the letter, the recommendation letter that an applicant obtained from a religious organization in Africa trying to prove membership. They wrote this letter confirming that, this person has been a member of our church for the past 5 years. This is what this person does in church and all of that. But immigration, for some reason, like I said, I don't know what triggered the red flag, but they decided to investigate it. Guess what? At the end of the investigation, it was proved. They provided documentary evidence to show that this person who claimed to be a religious worker, this person was actually a fashion designer in Africa. So, imagine if the R1 was approved and that person is trying to bring his or her family here. These people are not stupid. They are not stupid. You cannot tell them in Africa that you are a fashion designer and then suddenly turn to a religious worker in America. It doesn't work like that. Although some people get away with it, but others don't. So, to go back to your question, do my family members automatically get R2? No, sir. No, ma. I don't know if this question is from a man or a woman, but is it automatic? No. Is it possible they get R2? Yes. But is it automatic? No. So I hope I've been able to explain that question clearly. So keep the questions coming in. We have about 10 more minutes to go. Okay. Can someone do a Freedom of Information Act request if their non-immigrant visa was denied to see the reason why? Well, anybody can do a Freedom of Information Act request. However, the same way you have the freedom to ask questions, the government, U.S. government, either through USCIS, either through CBP, either through ICE, or even either through the Department of State, they also have right to protect their officers. They have right to protect their own investigation. So even if you apply for the FOIA, they can respond to your FOIA without providing confidential information. They can respond to your FOIA without providing the information they use to in their investigation. They can respond to your FOIA without providing the identity of the people they questioned or they interviewed or their strategy, their source, all these things. They are protected by law. So they can respond to your FOIA and not provide any of this information. I remember about 3 years ago, a client came to my office. This client had somebody filed asylum application on his behalf. Now, unfortunately, this is one of the people who claim to be lawyers, when in fact this person was not. He was just an agent who probably had an idea of how to file an asylum, but without actually understanding what an asylum is. So this person filed an asylum on behalf of this client that came to our office. So when the client came, I started asking him some questions. What was the basis of the asylum? Why? What ground did you use? Where is the story you presented? So all the questions I asked this person, he had no clue. He had no clue what was submitted on his behalf. All he knew was that asylum was filed on his behalf, and he has the receipt notice. And I told him that, unfortunately, I will not be able to represent you if I don't even know what you have submitted previously, because I don't want to take steps that will contradict what you already did, since I don't have a way of knowing what you already did. So, long story short, we decided to do a FOIA, Freedom of Information Act, to request for copies of our file, copies of the asylum application, copies of the stories and everything. We submitted it. Immigration responded to it. They gave us copy of the application itself, but every single supporting document, including the story, they did not provide it, because at that time they already knew that this was a fraudulent asylum, and they already started investigation on that particular asylum. So at the end of the day, they responded to the FOIA, but they didn't provide the information. So the point I'm making here is that the fact that you apply for FOIA does not mean you will get that information you are asking for, especially if that information is an information that is useful to them, that is an information that will expose their system, if it's an information that exposes their strategy, if it's an information that exposes their mode of operation, they are not going to release that information to you. So I hope I've been able to answer that question. The next question. So, are there limits to what immigration can do to investigate application or petition? Well, when you say limit, I don't understand that. What I know is that once an application or petition triggers red flag, it means red flag does not necessarily mean denial. Red flag does not mean, what red flag means is that something is not clear. We need to investigate it, investigate further, ask questions. That is what red flag means. So once your petition or your application triggers a red flag, when they start investigation, you cannot limit what they can do when it comes to investigation. They have the right to investigate because you are seeking a benefit. Either you apply for a waiver, a visa, or you apply for green card, or you apply for legal status. You are asking for a benefit. And if your application triggers an investigation, I don't think there is a limit to how far they can go. Like some of the examples I've given in the past, I've seen investigations conducted in family-based cases. I've seen investigations conducted in employment-based cases. I've seen investigations conducted in religious petitions. I've seen investigation in everything. Even investors, those who come into the U.S. to invest their money, they can still be investigated. They want to know the source of their money. They want to be sure that this person is not involved in drug trafficking. They want to be sure that this person is not involved in money laundering. So there is no limit to the extent they can go for investigation once an application or petition triggers investigation. So the best thing to do is to file an application that will not trigger investigation if you don't want them to investigate you. But again, from experience, we have seen people who apply for visa, provide some kind of information, and then they come back, they get to the US here, they file application for change of status and provide contradictory information. These are the type of things that triggers investigation. So I believe we are going to round up today. Okay, I think that's the last question. So for example, can they get phone records of someone? Again, like I said, I don't have access to their mode of investigation. That is what they have guided jealously. Even as lawyers, when we request for these things, they don't provide their method. They don't provide the tactics they use. They don't provide their mode of operation. Because if they do, it will probably hamper future investigations. So they don't provide all these things to us. So if I tell you yes or no, if I tell you one way or the other, I will just be guessing. And guesswork is not a good thing. We don't even do that in this office. So today, we'll be rounding up this program. We've been on for the past 2 hours. So hopefully you remember to join us next week. Again, this program will be every Wednesday, 12 p.m. That is Central Standard Time. Join us every Wednesday, 12 p.m. Central Standard Time. That is Dallas time. There is no string attached. No consultation fee is required. So make sure you invite your family, friends, join us, subscribe to our channel so that when we go live, you have the opportunity to be notified. The only reason we do this is to provide information to our people so that we prevent avoidable mistakes. So don't be selfish. Make sure you invite others. As you have benefited from today's program, I'm sure that it will also be a good thing to let others know that this type of program exists so that others too can benefit. By providing information to people, we are doing our own best. This is our own way of educating people so as to prevent avoidable mistakes. Even the Bible says our people perish for lack of knowledge. We are trying our best to provide knowledge to people so that they don't make avoidable mistakes. Join us again next week, Wednesday, 12 p.m. Dallas time. That is Central Standard Time. God bless you. God bless you. Advert. Anyone, start one first. Am I still live?
I was looking for Lawyer Asekun for help concerning my immigration status because everything was upside down. Because I couldn't believe, I was even thinking maybe I'll be sent out back to Nigeria. So on getting to know him, he explained everything to me, what I'm going to do, that he's going to do everything. So fortunately for me, everything was done from him. Dr. Lawyer Asekun is the best lawyer so far in Texas because I can introduce as many as whoever is having problem, especially when it comes to immigration. I'm going to introduce Lawyer Asekun because he's the best lawyer. So far, so good.
Our goal here is to make our clients happy, especially in the area of immigration, family law, and personal injury.
I was looking for Lawyer Asekun for help concerning my immigration status because everything was upside down. Because I couldn't believe, I was even thinking maybe I'll be sent out back to Nigeria. So on getting to know him, he explained everything to me, what I'm going to do, that he's going to do everything. So fortunately for me, everything was done from him. Done to me what I'm going to do, that he's so far in Texas. Because I can introduce as many as whoever is having problem, especially when it comes to immigration. I'm going to introduce Lawyer Asekun because he's the as whoever is having problem.
The pressure was that it was a man that you can rely on. They work with me, they work with me like it became something like family, right? It was no longer like, okay, this is a client, this is somebody you are providing you service, right? So it became something like a family. So yeah, I can see the relationship was good working with his staff. People give me encouragement, but I will look at it and say, how is it possible? I said, it is not going to be possible. That's why I kept telling myself that it's not going to be possible. But he knew what he was doing. Like I said, research is very, very important. If you do research, you will learn a lot of stuff. There are a lot of immigration rules some people don't look at. There are loopholes there, and sometimes they purposely put them there. So it's research, and it's using those research to help a lot of people, not just me. It is not just me. It is a lot of people here many people here that he has helped. Many people. Sometimes it doesn't even charge them. When it comes to the point that it doesn't even charge them. So yes, if you are looking for an immigration lawyer, even if I'm sleepy right now, if I'm like sleepy, you wake me up, you say, do you know an immigration lawyer? I won't even blink, I will say it, Dr. Asekun is there, I will just say it. So, yeah, that's how good he is.
Talking about immigration, as an immigrant myself, I always put myself in the shoes of clients because I've passed through the immigration process and I know how hard it can be on people when they don't have the legal documents to work or to do day-to-day activities here in the United States. So that personal touch makes a big difference.
The law office of Olu Asekun is special because we like to put ourselves in our client's shoes.
For Dr. Asekun, for me, I will forever be grateful, and I keep telling people he's the best immigration lawyer you can have. He's the best immigration lawyer you can have. My first impression was that,
let's face it, if you or your loved one has been wrongfully injured by the negligence of another, it is important to retain the most reliable personal injury attorney possible. At the law office of Olu Asekun PC, our dedicated team of attorneys, comprising of Dr. Olu Asekun, Texas and New York licensed, Ya Adubafor, Texas licensed, Jane Asari, Texas licensed, and Olatoyosi Asekun, Missouri licensed, will fight for your rights. Whether your injury was the result of an auto accident, slip and fall, wrongful death, or medical malpractice, we offer representation on a contingency fee basis. That means that if there is no recovery, you pay us nothing. Contact us on oluasekun.lawyer to know more, or call, text, WhatsApp our office at 817-891-6655. 817-891-6655. Let's face it,